To the Adam Bernard's podcast. Today I'm thrilled to have Fawzia Azim. She's the head of legal operations in the US immigration with us. Fawzia, please introduce yourself and tell us about your role in US immigration.
Hi everyone, I'm Fawzi Azim, and I've been heading the U.S. Immigration Department, the legal operations wing here at Adam Bernard, and I've been practicing U.S. immigration law for the last 10 years. It gives me a privilege to serve clients, help clients sort out their various immigration issues and challenges that they face on a day-to-day basis. And yeah, we've got really good success rates at Adam Bernard's.
So, Fawzia, many entrepreneurs want to know who qualifies for an E2 visa, how much investment is considered enough, and can they bring their family members to join and work and study with them?
Yes, Daniela. So it's quite an unpopular popular visa category for individuals who want to start their business in the US. A small scale startup which is profitable, and the main criteria is that the nationality of the applicant must be of one of the countries that the US has got the treaty or trade agreement with. Yeah, that's the main criteria. Regarding the investment, the USCIS or the legal standard says that a substantial investment needs to be made. When it comes to substantial investment, we're not looking at any fixed amount, but however, there is something called the proportionality rate. So the projected cost of business must align or must be in proportion with the amount invested. And there are a couple of other criteria as well, which I'm happy to discuss during client consultations, or it would be more sort of like a tailored advice rather than giving a generic advice. But these two are the two main criteria that the clients must meet or the applicants must meet in order to qualify for E2 visa.
Okay, brilliant. What are the common mistakes that are made with these applications?
More often than not, the clients, or when the clients approach us, they say that, Fauzia, our visas got denied. Now what do we do? Well, the either you could appeal, but there's no scope to appeal and then get an approval. The mistakes that clients mainly make is that they do not do their business profile evaluation before starting the application. And well, it's an extensive application, but clients do think that it could be done in less. In a very least amount of drafting, but it involves extensive investment spreadsheet drafting to be done, calculation of each and every investment, how it's being made, from both the countries, that's from abroad to the US. So I would say proper documentation when the clients they do not do, that's when the cases get rejected, and that's a very common mistake that clients do make. And they do not do a proper profile evaluation whether their business meet the criteria before applying for an E2. So I would recommend everyone to do a profile evaluation, which we at Adam Bernard's we do. So yeah, that's a common mistake, Daniela.
Okay, brilliant. Rosa, I've heard of an O1 visa. Is this a potential route if someone doesn't meet the criteria of an E2 visa?
Well, good question, Daniela. But E2 and O1, both are non-immigrant visas. That means they're temporary visas. However, both have different criteria and objectives. So, for example, if an applicant wants to travel to the US and work in the US, well, O1 is a good option. But if they want to start a business, E2. But the main point, or what works best for the O1 applicants, is that um, applicants of any nationality can apply. So not just the nationalities of the treaty and trade countries, and but however you must meet the strong legal standard for an exceptional talent. So if you recognize yourself as exceptionally talented in the field of your work, definitely O1 is the right criteria category.
Okay, perfect. Can an O1 visa lead to a green card?
Yes, Daniela, that does lead to a green card because O1 has dual intent. That means once you're on your O1 route, after 3 years, potentially you can file, or your employer can file for a green card petition, which is called the I-140 petition.
Perfect. Got that there. So, Fawzia, which individuals from industries can apply for an O1 visa?
O1 visa doesn't restrict to one single profession or having, it's not like an H1B where you need to have a specialty occupation. It is applicable to people of various industries. Like I've got clients from the media industry, from the music industry, a DJ. So yeah, I've got also blockchain tech consultants, CEOs. So people who can recognize themselves as exceptionally talented in their field, whether they are researchers, whether they are tech professionals, whether they are producers, directors, music artists, even chefs can apply for O1.
Can you please explain the difference between an EB2 and an EB2 and IW?
Okay, so EB2, broadly classified as employment-based green card routes or visas, EB2s are mainly sponsored by employers. That means you need to have a job offer. The employer files for a perm application. EB2 and on the contrast, EB2 national interest waivers or NIWs, they are more inclined to a self-sponsorship routes for a green card. So if you identify yourself or if you identify that your profession is of national interest to the US and your achievements do align with the national interest of the US, then I would say EB2 NIW is the right route and it's self-sponsored. So you can sponsor yourself. You do not need to wait for a job offer or an employer to submit a perm application and therefore proceed. Also, it's important that both these categories do have a requirement where you should have at least a bachelor's degree or an advanced degree with a PhD. If you have bachelor's, then you would need to have substantial work experience for at least 5 years.
Okay, perfect. Many of our readers want to know who qualifies for an EB1 and how different is it from the EB2?
I would say EB1 is an extension of an O1 visa. So O1, as I explained earlier, it's a non-immigrant visa. It comes under the temporary visa category. EB1 is just an extension. That means the criteria are a little bit more extensive than O1, but however, you need to explain to the USCIS or the United States of Homeland Security that your work has been of substantial merit and you have risen above the 1% of the talent in the field that you've worked in. So EB1 is basically an extension of O1, but it's a green card. It's the green card route of an O1.
Okay. We need to know what are the common mistakes that can delay approvals.
Is that a generic question?
It's just a generic question that
Okay.
many of our readers want to know.
So the common mistakes, I would say not drafting the form correctly, even the dates if they're not in the US format, because most of my UK clients, they mess up the dates. So the dates must be in accurate format. The filing fees, importantly, if you mention it incorrectly to the USCIS, the petitions can be rejected straight away. And the main mistake is that, especially for heavier petitions, extensive petitions like O1 or EB1s or EB2s, if the clients have not properly done a profile evaluation, they would not know the strength that they need for each criterion, and therefore a profile evaluation is really mandatory. It's a prerequisite before you apply. Otherwise, it can come back in a refusal or an RFE, which is request for evidence, which can lead to a denial as well.
So Fawzia, I have my friend. She is a US citizen and her partner's a British citizen. They both live in the UK. What is that best application for them to make to go live in the US?
If they both are in the UK, the US citizen spouse, he or she, they might need to file an I-130 marriage-based green card. That's the quickest and easier route. There is a route where you can fast track this, especially with the time frame, because I'm sure that my audience, everyone knows that it takes such a long time to process I-130 marriage-based green card. It can go up to more than 14 months, over a year, in order for the USCIS to approve an I-130 marriage-based green card. However, at Adam Bernard's, we have a specialist team, and we can fast track. We can strategize the case in a way that the I-130 case can be expedited to a shorter wait time. Well, this is some extra bit that I gave you, Daniela. But to answer your question, it's an I-130 marriage-based green card where the U.S. citizen spouse needs to file an I-130 petition for their non-U.S. citizen spouse, who I assume is a British citizen. And yeah, as soon as they can file, there's a wait time, and then the non-U.S. citizen spouse can relocate. Both can relocate to the U.S.
So in this case, Fozia, what's the most common reasons why the petitions are refused?
Um, Most likely, if they cannot prove their marriage, as in if they don't have any joint documents together. But in your friend's case, I assume they both live together and they have been living together. So if, as long as they can produce joint documents together, anything like joint mortgage statements, their even their photographs together. Yeah, and joint tenancy agreement, bills, anything where they have both the applicant's name, the petitioner's and the beneficiary's name on any proof, that can serve as a strong evidence for an approval. But if the applicants cannot evidence that, that's when a petition gets refused for an I-130.
Any specific pictures they need to show?
Well, the USCIS recommends normal pictures. Let me put it that way, Shagina. But however, they would appreciate any pictures that can depict their strong relationship, as in the wedding pictures, picture of the honeymoon together, like obviously outdoor pictures. Yes, anything that supports the marriage, the relationship is part of a strong evidence for the petition.
Okay, perfect. Okay, Fozia, now we're on our rapid fire round. I'm going to ask you 3 questions. I've already pre-prepared them for you.
Okay, shoot. Eating lunch, please, Daniel.
All right. What's the biggest myth about U.S. immigration?
The biggest myth about U.S. immigration, I would say, these days is that the petitions or the applications will get refused or denied no matter whatever evidence you provide. However, this is not true. We've had a good number of cases approved in the last 1 year, also in the last 6 months, I would say. So I would say the myth that the new administration is being strict. Well, it is strict, but however, U.S. immigration has always been strict when it comes to legal standards, criteria. If an applicant doesn't meet, it's a straight up refusal. So I would say the myth that the current administration is trying to adjudicate petitions strictly and refusing them, that is a myth, because we've really got a good number of approvals in the last couple of months.
I'm sure that's very true. I reckon that's true. All right. What's the one tip for applicants in 2026?
I can't just pinpoint on one tip, Daniela, but I would say a good initial consultation is a must, no matter what route you take, and understand your background, how you stand in front of like the U.S. Immigration authorities' point of view, as in how your case is currently standing, whether it's strong, it's weak. So a good consultation will help you narrow down the best route for you. Each petitions are not. We do not have any generic categories for U.S. immigration matters. So if you need to narrow it down, I would say that's one important tip, that get a legal help to narrow down which is the best route for you. And yeah, and then you can understand how strong your case is and therefore can get a good outcome.
Okay. So obviously there's many visas to apply for, but which one is the most misunderstood visa?
There's nothing called misunderstood visa, but I would let me reframe your question. The most difficult visa to get approved for British nationals or any nationals is a B1, B2 visa. Why I say this, I'm pretty sure everyone knows what a B1, B2 visa is. It's a visitor visa. It has the highest rate of refusals only because the decision is discretionary. So the consular officer decides whether they would want to grant you the visa or not, and there's no scope to appeal. So I have reframed your question.
Right.
So yeah, the most difficult visa to get approved is a visitor visa.
Okay. Someone wants to get in contact with you at Adam Bernard. How can they contact you?
They can call us on our phone numbers or contact us via our contact form on our website. They can either reach out to me or Joseph Solis, who is our managing attorney, who is based in Houston. We've got offices globally. We've got New York, Houston, and 2 offices in London. Yeah, you can reach out. Our details are on our webpage, and yeah, we're available for a quick consultation.
Perfect. So thank you for joining us at our Adam Bernard's podcast. Please join us in the next one for episode 2, where we'll be talking to you about more immigration matters.